All right. So for my case brief assignment, I was assigned the Kaufman versus Garnett, which took place in Virginia, and the case was filed on January 10th, 2003. So some facts about the Kaufman versus Garnett is that in the fall of 2000, Andrew Kaufman, a 13-year-old middle school student at a public school in Potomac County, began participating on the school's football team. It was Andy's first season playing organized football, and he was positioned as a third-string defensive player. James Garnett was employed by the Potomac County School Board as an assistant coach for the football team and was responsible for the supervision, training, and instruction of the team's defensive players. The team lost its first game of the season. Garnett was upset by the defensive players' inadequate tackling in the game and became further displeased by what he perceived as inadequate tackling during the first practice following the loss. So in the next practice, Garnett ordered Andy to hold the football and stand upright and motionless so that Garnett could explain the proper tackling technique to the defensive players. Then Garnett, without further warning, thrust his arms around Andy's body, lifting him off his feet by two or more, and slammed him into the ground. Andy weighed about 144 pounds, while Garnett weighed approximately 260 pounds. The force of the tackle broke the humerus bone in Andy's left arm. During prior practices, no coach had used physical force to instruct players on rules or techniques of playing football. Andy's parents, Richard and Rebecca Kaufman, individually and on behalf of Andrew, filed a Second Amendment motion against Garnett in the Virginia court for gross negligence, assault, and battery. So the issue is that may a plaintiff sue for battery upon receiving an injury while playing an organized sport if the plaintiff did not express or implicitly agreed to harmful contact? And that's like especially with football having football be such a high contact sport. Can the parents sue for battery on the kid? So the rules of law would be like gross negligence would be number one. The Kaufmans presented a sufficient basis for pressing their claims of gross negligence. Gross negligence exists where the defendant acts in complete disregard for the plaintiff's safety. In this case, Garnett's knowledge of the size differential between him and Andrew, combined with his implicit direction that Andrew not defend himself, the amount of force he used, and the lack of previously instructed players using physical force could lead a reasonable juror to conclude that Garnett acted with gross negligence. The second rule of law was battery. A battery consists of contact that is unwanted, unjustified, unexcused, and not consented to. Here the Kaufman stated sufficient allegations to make Andrew's consent a jury question, while Andrew's participation on the football team signified consent to being tackled by the other players. The scope of such consent may not have encompassed being tackled by an adult coach, particularly where coaches had not previously used physical force in the team's training. The last rule of law was assault. An assault is carried out by a threat of bodily harm coupled with an apparent present ability to cause the harm. It is both a crime and a tort, and therefore may result in either criminal or civil liability. And just as like a PSA, assault is the intent of contact, and then the battery is the physical contact. So they usually go together, but a lot sometimes they can be separate. So for my analysis, Andy and his parents alleged that Andy was injured as a result of Garnett's simple and gross negligence and intention acts of assault and battery. Garnett actually argued that the Kaufmans had not alleged sufficient facts to support a lack of consent to the tackling demonstration and therefore did not plead causes of action for either gross negligence, assault, or battery. The trial agreed with Garnett and dismissed the case. In doing so, the trial court held that under state law, Garnett, as a school board employee, was entitled to sovereign immunity for acts of simple negligence. So for the duty of a coach, it's like their duty to make sure that the players are properly trained in tackling, especially on the defensive side. If you're not tackling correctly, you could obviously injure yourself and the other player. So it was his duty as a coach to participate in drills and show his players how to tackle properly. Obviously, his breach of duty was mismatched. He is obviously a way bigger person, and tackling someone half your weight will cause damage towards the individual, and so that was his breach of duty. And then the causation was him picking up the player and tackling him to the ground, and obviously the injury or harm was his left humerus. So in conclusion, the trial court found that facts alleged by Kaufman were insufficient to state causes of action for gross negligence, assault, or battery because the instruction and playing of football are inherently dangerous and always potentially violent. It is the coach's duty to provide the players with sufficient technique, and with becoming a coach, it is their job to do demonstrations and teach. The dissenting judge found no evidence that the tackle itself violated any rule or usage of the sport of football. On the contrary, since Andy could not have been tackled by a larger, physically stronger, and more experienced player, either during a game or practice, the dissenting judge found the alleged battery was still within the participant's scope of consent to bodily contact permitted by the rules and usages of football. So the judge said that with playing football and signing up to play football, you're consenting to being tackled by either a player or a coach. And that is it. Thank you. Do you have any questions?